Welcome to the Superior Court Traffic Department. This message contains important information about how this court session will be conducted, including the advisement of your rights, a description of choices in paying fines, and information about traffic school, so please listen carefully. You are here today because a law enforcement officer has issued a citation charging you with a traffic or other minor infraction. Although an infraction is the least of the offenses that can be charged by the state, you have a number of rights under the Constitution that I'm going to advise you about. En español, si usted no entiende inglés y necesita un intérprete que le asista, por favor, dele a saber en este momento al alguacil o oficinista y se le llamará a un intérprete.
Be certain that you have checked in at the traffic window. The paperwork that the court needs in order to handle your case is generated at that time, so if you haven't checked in, you will not be called. Many routine matters may be handled at the window without waiting to appear in court, such as showing proof of correction of registration or insurance, traffic school if you're eligible, and pleading not guilty to set your case for trial. If you wish to plead not guilty and set your case for trial or simply show proof of correction, you may return to the traffic window to handle the matter now, even if you've already checked in. Many of you are appearing simply to request a reduction in your fine. Be advised that fines are established by law and are not likely to be reduced by the court. If you plead guilty or no contest, the judge will review the facts of your offense, and in some cases the penalty may be increased according to the circumstances of the citation. For example, the computer does not generate license suspensions, whereas a judge may suspend your license when the speed is exceptionally high or the driving was exceptionally dangerous.
This procedure was established under the state and federal constitutions as a right called due process. Due process is defined as your right to be informed of the charges against you and your right to respond to those charges. Traffic court is a criminal court, and you have the same rights here that you have in any criminal court, with some minor differences. You have the right to an attorney at every stage of your case, including today. If you want time to hire or consult with an attorney, let the judge know and you will be given time. If your only charged offense is an infraction, you do not have the right to assistance from the public defender or court-appointed attorney in traffic court. On the other hand, if you are charged with a misdemeanor, such as misdemeanor failure to appear or speed contest, and you cannot afford to hire an attorney, you have the right to appointed counsel at public expense. You have the right to remain silent on the facts of the case. It's up to the law enforcement officer who issued the citation to prove the case against you, and you don't have to say anything. If you do decide to testify, the judge can ask you questions, and anything you say will be considered in the decision to determine whether you are guilty or not guilty. You have the right to a public and speedy trial. That means your trial will be heard by a judge or commissioner. If you demand a speedy trial, it must be held within 45 days of today. If you waive or give up your right to a speedy trial, then you can have a date available in the future and schedule your trial around your work or school activities. You do not have the right to a jury trial for traffic infractions, but you do have the right to a jury trial for any misdemeanor, such as misdemeanor failure to appear. At a trial, you have the right to confront the witnesses and evidence against you. The court will subpoena the officer who cited you, and he or she will personally come to your trial. You have the right to ask the officer and other witnesses questions, examine the officer's notes and any other documents he or she presents at your trial. You have the right to introduce your own evidence, including your own testimony, witnesses you have, any photographs, diagrams, or other proof that you are not guilty. You may use the free subpoena services of the court to order your witnesses to appear and to request police reports or other documents. You also have the right to appeal if you are found guilty. You have 30 days after your trial or notice of the decision to notify the court that you are appealing. If you live far away or have a busy schedule, you may want to conduct your trial by mail. This is called a trial by declaration. You will submit to this court in writing and under oath what you want us to consider in your particular case, explaining what happened and why you believe you are not guilty. The officer who gave you the ticket may also appear by declaration. Both sides have a deadline by which to mail back their paperwork. We require you to post bail if you have a trial by declaration, and this is only available to you if you have appeared no later than the appearance date on your citation. When your name is called, come forward to the front of the courtroom. The clerk makes a record of the charges and your responses, and you will leave the court with paperwork showing what happened in court. The bailiff is here to maintain order in the courtroom, to take any papers that you may have the court to review, and to provide you with the record prepared by the clerk. The judge will advise what you are charged with and the date of the offense. You may respond in one of three ways: guilty, not guilty, or no contest. You can plead guilty, which is an admission of the charges made. The court will impose a fine and may allow traffic school if you have not been there for an offense that occurred within 18 months of this current offense. Community service may be available in lieu of a fine if you wish. You may also choose to pay your fine today, or make payments, or get an extension of time to pay and complete traffic school. If you choose to do community service, be aware that there is a charge for signing up and a security fee that must be paid. Also, civil assessments for failing to appear must be paid even if you do community service for the fine. The second reply you can make is no contest. The difference between guilty and no contest is like this. Suppose the law enforcement officer says that you were doing 65 in a 25-mile-an-hour zone, and you believe you were only doing about 50. A lot of folks will be upset by this and convinced that they were not doing what the officer charged, but actually if you were doing 50 in a 25-mile-an-hour zone, you would probably be convicted of doing more than 25, which is what the charge says. One way to deal with that is to say no contest. It's a way of saying I didn't do everything the officer says I did, but I did violate the law. The same options of fine, volunteer work, and traffic school are available in this case. Additionally, if you are sued in civil court because of something involving this citation, your guilty plea can be used against you. As an example, if somebody sues you saying that you didn't stop at a stop sign, you hit their car, and now they want money to pay for the damages to their vehicle, they can use your guilty plea as proof in the civil court case that you didn't stop at the stop sign. If you plead no contest, they may not be able to use that plea in their civil case. They must prove their entire case. The third option you have is to plead not guilty, in which case the matter will be set for a court trial. In that event, you will be asked if you want a speedy trial or if you waive time. When you choose a speedy trial, the trial will be set in about 30 days. If you waive or give up that right, the trial may be set after 45 days, and it gives the court some flexibility to set a date that may be more convenient for you. At a trial, you have the right to cross-examine all witnesses against you and to present evidence in your own behalf. If you do not appear at the time set by the court for the trial will proceed in your absence, and a decision will be rendered based on the evidence presented. Many of you are here because you did not have evidence that you were covered by insurance when you were stopped, or you had an accident and had no car insurance. This is a very expensive offense in California, but it is also a correctable offense. If you had insurance at that time but didn't have proof with you, you don't have to plead not guilty. Just show proof that you were insured, and it will be dismissed with a proof of correction fee. In many cases, this can be done at the traffic window. If you didn't have insurance then, but you have insurance now, your fine may be reduced. Please be aware that it is no excuse that it was not your car. In order to be allowed to drive a vehicle on the streets of California, it is the driver's responsibility to see that the vehicle is registered, insured, and otherwise legal to be on the road. If you plead guilty to driving with a suspended or revoked license, you will be admitting that you knew of the suspension as required by law. If the DMV mailed notice to the address on file for you, you are charged with notice whether or not you actually received it. If you have been cited for driving without your valid license in your possession, it is correctable by presenting a valid license and paying a proof of correction fee. If your license is on hold by the DMV for not appearing in court, that hold will be removed tonight by computer because you appeared in court today. The civil assessment is not relieved by your appearance. If the DMV hold is for failing to pay a fine, the hold is only released by paying the total amount due.
Your matter will be heard in the order in which you checked in at the traffic window. If a fine is ordered, you will be given time to pay the full amount due. If you wish to pay the amount due in monthly installments, contact the court's collection unit about a week after this court appearance to arrange a payment amount according to your ability to pay. In some cases, you may be allowed to satisfy the fine by performing community service. If you are requesting community service, please request it from the judge when you enter your plea. Community service will not be allowed to cover the amounts due for failing to appear or failure to pay a fine. Those amounts must be paid in full. When you have been charged with a correctable offense, the charge will be dismissed when you provide proof of correction to the clerk or to the court and pay a proof of correction fee for each count. If you cannot pay the fee now, you will be allowed 48 hours to pay all correction fees. Paying the fees within 48 hours will result in the dismissal of that count. If you fail to pay the correction fee, the case will be referred to the court's collection unit. A processing fee will be added, and the count will show as a conviction on your record. After your matter has been heard, wait to receive your paperwork from the bailiff before leaving. The bailiff must be attentive to events in court, so do not ask questions while the court is in sessions. Take your papers to the window outside to make payments, ask questions, or sign up for traffic school, or to obtain papers for volunteer work.
Please turn off all cell phones and beepers now. Do not read or talk with your neighbor to keep the noise level down. We will be starting momentarily.